Mr Speaker, I know that you'll be surprised that I'm taking the call given the chair of the Select Committee that was referred the Statutes Amendment Bill, but now that a member of the committee has given such an erudite explanation of the details of the report back from the Government Administration Committee, I'm sure that my colleague doesn't mind that he's not taking this particular call. I want to take a couple of minutes just to talk about some of the things that I think are really important about the process. Number one, of course, I do like the omnibus bill approach, as I've said in this House on numerous occasions. The Statutes Amendment Bill is specifically focused on those very minor, technical and non-controversial amendments to existing statutes. So there are issues that are not really open for debate, but they are certainly matters that do need to be addressed, but they do not justify the attention of the House as a single separate items of business. And I do think that there should be more opportunities for omnibus bills, and as I've said in this House on several occasions, that the area of regulatory improvement is one that I do like to see, and I note that the government have taken up the bill that was in my name, Regulatory Improvement Bill, and have decided to adopt that as an annual process. Now, this particular bill, though, does contain a controversial matter, but it's not controversial because of what it is intending to do. It is controversial because of the decision that occurred prior to us having to amend the law to reflect a change that took place outside of this place. So I will mention that one in a moment.
Thank you.
So I've got you all hooked now, haven't I? Absolutely, on a Statutes Amendment Bill. But I think that the other thing that I did actually want to refer to with respect to the report back from the Select Committee was that the Select Committee identified an error in terms of one of the 47 statutes administered by 15 different agencies that it is amending. And they found a small issue in Clause 156, Paragraph 2 of the bill, where we would have recommended an amendment, but they decided, and I thought this was a very sensible suggestion, to not to require the reprinting of the bill for such a minor amendment. And I thought that was exceptionally well considered, and I'd like to congratulate the chair of the committee, who obviously led that decision.
He's been silenced by the government.
That's right. And so, but anyway, I actually think it is worth mentioning that when we're dealing with non-controversial legislation such as this, then sensible arrangements can be entered into. And actually a bit of leave for the chairman of the committee to speak on the bill might have actually meant that you didn't have to put up with this very lengthy speech that this is now turning out to be. But that's all right.
Not go with the woman with the trees.
But the one...
She doesn't get the feel of the House.
The one issue that is controversial, but not because of the bill, but because of the decision that preceded the bill, is Part 29. Part 29. Part 29 is the New Zealand Institute of Chartered Accountants Act 1996. And the reason for the controversy around this is their appalling decision to change their name from ICANS to NZECA. And I just think that's an outrageous thing for them to have done. Now, it did actually, yes, I know, and it was so much easier just to talk about consulting with ICANS, and everyone knew exactly who you were talking about. And now you're NZECA, because we can't help ourselves. We've got to turn everything into an acronym, of some sort that makes some sort of sense. So, even if it doesn't make sense, like NZECA, I mean, that doesn't really sound like the worthy body that our chartered accountants actually are. But no, seriously, the particular amendment is required because, of course, they have changed their name, and in fact those changes were made quite some time ago, and it is time that we updated that particular statute to bring it into line. I understand that the Minister at some point when the committee stages are being held in the House, that a Minister will provide some information on the Wills Act 2007. I think it is important to put that on the record because there is an important aspect that has been raised with respect to a late submission on clause 196 paragraph 1 concerning the validity of wills according to the Wills Act 2007. And finally, there's obviously been a bit of debate around the Protection of Personal and Property Rights Act 1988, and I actually agree with the Select Committee's recommendation on that, in that regard, in the sense that no further changes be made to clause 119, but that the review address any remaining concerns about section 94A, and I think that's a very sensible way to address the particular issues that was raised by way of submission. So very pleased to see the bill back in the House. Again, I'd like to commend the chair of the Government Administration Committee for the superb work that he did, and obviously with a very dedicated team on that select committee assisting him very ably in that process.